can be seated, thank you. All right. What do we got, Mr. Rosenwasser?
Your Honor, yesterday I was going through Mr. Knox's stand your ground and deposition testimony and looking at the pictures of the mannequin recreation that Your Honor has. So I wanted to supplement my argument with this. I'm not 100% positive if all these factors came up during the argument. As the court knows, with respect to simulation case law, it's generally frowned upon. I wouldn't even consider this evidence as simulation. I would categorize this evidence as irrelevant, completely irrelevant, for the reasons that I'm going to discuss. And again, even if it was relevant, the relevancy of it would be substantially outweighed by the prejudicial effect. Okay? So in looking at these mannequins, all right, so this is what Mr. Knox has done. He's taken mannequins. So let's just use it. It's going to sound funny when I say mannequin Chad, but that's how I'm going to refer to it. Okay? So if you look at mannequin Chad is not the same height as real Chad. Mannequin Chad isn't the same body shape as Chad. He doesn't have the same face, musculature, dimensions, shoulder. Basically, just to sum it into one big argument, mannequin Chad does not even get close to real Chad. So it can't be relevant to anything in this case. Then you have, I sound so silly when I say it, mannequin Nicole, okay? Mannequin Nicole is not even remotely close to actual Nicole in any respect. Height, weight, dimensions, the way the body shapes. I mean, let's say that mannequin Chad is 2 inches, 4 inches, 6 inches off. That changes the whole quote-unquote perception that supposedly the jury's supposed to see. If Nicole Oulson isn't anything like Nicole Oulson, then the perception is totally off. It's not relevant at all, and it's so misleading for the jury because it's so inaccurate, it can't have any relevancy to the case. And that's just the very beginning of the analysis. So in the background, we have a movie that's playing that's not the actual movie that was playing at the time of the shooting. So the lighting in the pictures on the mannequin that doesn't represent Chad, that has to affect this perspective that the defense is putting out of the defendant. Then, let's just say for the sake of argument, which isn't the case here, that it was the movie playing. We do not know what scene was playing at the time. So let's say that they were in a car, versus they were in a house, versus they were at the beach. The scene lighting that we don't know would be different. You couple that with mannequin Chad that's not even remotely close to the dimensions of real Chad or even real Nicole. It can't get more misleading than that because we're having factors that aren't even at play in this case. It's not even like, well, maybe it's somewhat similar. There's nothing at all remotely similar to what's going on in this case. Coupled with that, this is what you have, and this is what I read from the deposition. In the deposition, the camera position is from Michael Knox sitting in the movie theater chair. It's not even as if the defendant was there for the recreation. It's Michael Knox sitting in a theater chair taking a photograph that now the jury's supposed to say, well, let's look at this picture taken by Michael Knox as Michael Knox is viewing it from a theater chair with mannequin Chad that doesn't even accurately represent real Chad against the backdrop of a movie that's not the movie playing, and the lighting conditions can't even be recreated because it's impossible. On top of that, the picture that was taken was from a tripod. The tripod was on the ground. So it's Michael Knox sitting, looking through a camera. The camera is on a tripod on the ground in front of Michael Knox, taking a picture of mannequin Chad that doesn't represent real Chad against lighting that doesn't replicate, nor could it ever replicate, the lighting at the time in the theater. It goes on and on and on. We don't know the distance. He has a picture of some random distance between the camera that's on the ground, mounted on the tripod, to this mannequin Chad. I'm not going to go through it 500 times about how it doesn't represent Chad, but it's just some random distance that we're now showing the jury so the jury can say, wow, this is how the defendant must have viewed this. It's really so irrelevant because it doesn't help the jury at all, because it has nothing to do with what the defendant saw in the theater at the time of the shooting. And it's not has to do with the sheriff's office investigation, as we talked about the other day. There is no way anybody could ever recreate all those factors that occur in a movie theater. It's just not possible. That's why you have to rely on the video that's in evidence and eyewitness testimony, because that's the best evidence for the jury. There are so many different factors that I could keep going on about, but I think that the point really has been made, that there's just no way. I guess one of the other big things would be positioning. This was a dynamic event that happened. People are moving left, right, angles forward, backwards. This is a picture determined by Michael Knox, which is a snapshot in time determined by him in a chair at some camera level. That's his eyes, not even the defendant's eyes, but there's just no relevancy. It does not tend to prove or disprove how the defendant possibly perceived this event under the circumstances that he experienced it through. Because that's exactly what this whole issue is in the case. Did he reasonably believe that he was in imminent danger of death or great bodily harm? And really, only the people in the theater and the defendant himself knows that answer. This recreation or simulation, or however you want to characterize it, is simply not relevant, and any relevancy is absolutely outweighed by its prejudicial effect.
Response? No, wait a minute. According to the case law cited by the state in Brown v. State, first DCA opinion, the standard is the demonstrative has to be an accurate and reasonable reproduction.
And then, so my argument would be, this is not even remotely accurate, and it's extremely unreasonable based on all those factors.
All right, and so as you were arguing that, what came to mind was, the differences and likenesses that are pointed out, say, in Williams Rule hearings. You can enumerate usually a dozen factors on each side. So you went through a litany of differences. Obviously, in Brown, there was a glaring difference of, styrofoam versus a human head. But so with that context, Mr. Escobar, what can you tell me?
Your Honor, first of all, this is for demonstrative purposes. Mr. Knox is not going to get up there and say, well, ladies and gentlemen of the jury, this is exactly what Curtis Reeves saw. It is a demonstrative aid to have the jury understand backlighting. Mr. Rosenwasser wasn't here for probably 95% of the arguments that we had yesterday, so he may not know that. But this was a demonstrative tool to be able to show the jury what backlighting does when someone stands in front of another individual. If the court recalls, their own witnesses talked extensively about the issue of silhouetting. And we can't assume here in this particular case that every juror actually knows the effects of silhouetting. I find it ironic, and I mean this with all due respect to Mr. Rosenwasser, but I find it ironic that this investigation, the crime scene investigation in this case, was an absolute train wreck, totally incompetent by the Pasco County Sheriff's Office, because they didn't preserve the things that they should have preserved. They should have done all these things there at the scene. And because now they're not there, and we're trying to bring back some of that evidence, some of that experience to the jury, they're saying, well, if we do that, if we allow that to happen, then the easiest thing that the government can do and the sheriff's office can do from here on out is they don't take up any evidence. Because if they don't take up any evidence, then certainly, it's not going to hurt their case, because you're never going to be able to go in and now present evidence in a form that is necessary for this particular jury to understand backlighting. These mannequins aren't there for purposes of saying, hey, listen, this is the perception that Mr. Reeves had with reference to these two bodies that were coming at him. This is a demonstrative aid. And just like that styrofoam head didn't mimic what a human head in that particular case did, you got to allow some flexibility. That's the reason. That's the issue of reasonableness. You have to. I'm sure in the Brown case that they didn't measure how long was the nose and how far apart were the eyes of the mannequin. And the mannequin didn't have any hair, and so why not put hair on the mannequin? We can't get beyond the fact that this is a demonstrative aid. And at no time is Dr. Knox going to say, hey, by the way, I did this because I want you to see that this is exactly how Mr. Reeves viewed the backlighting situation.
All right, and just to kind of clarify for the record, I think, as I recall the testimony regarding the silhouettes, you said the witnesses used that terminology extensively. I believe it was your terminology every time. They just said yes, silhouette, yes. Was it what? Couldn't you classify it as a silhouette? Wasn't it a silhouette? Or did you think it was a silhouette? I don't want to be leading, but because I'm sure you weren't leading. But yes, indeed, that's how I remember the testimony. Primarily your terminology, but nonetheless, silhouette has been testified to, which is why I agreed yesterday with the defense on this issue. Now, what about, all right, so Mr. Rosenwasser, you're pointing out all these differences. And obviously, again, in the context of a demonstrative as opposed to substantive evidence, there is a little bit of leeway there, obviously. What about that?
I don't think if you change the name of it, it makes a difference when you're doing a relevancy or 403 analysis. If it goes into evidence, that's one thing, but if they're going to see it as a quote-unquote demonstrative aid, they're still seeing it as if it is in fact evidence. So it's just more a different word, really, than anything else. Now, when the defense says that we're using it for backlighting, okay, I don't think the jury needs an expert to talk about backlighting. That was something that would be within the common sense purview of a layperson. People know what backlighting is, so we don't need Mr. Knox to come up and say, wow, here's an example of backlighting. Really, it's a perspective. That's what I submit they're trying to do. Okay? Silhouette. We don't have a jury full of kindergartners that don't know what a silhouette is. Okay? The silhouette is within the common person's experience in their lifetime. We don't need Michael Knox to come in and give expert testimony on it, because people hearing silhouette, backlighting, that's not terminology that requires any further explanation. It's in the common purview that people know based on their life experiences. Experts are used when there's information that goes outside the experience of what we'll say is a common juror. Backlighting doesn't do that. Silhouette doesn't do it. And I was thinking the same thing as the court. Our witnesses didn't get up and say silhouette. Now, you know, that's just kind of, this is what lawyers do on either side. So I'm not saying in the fault. It's a job of semantics, you know, and that's just what lawyers do. But really, we don't need anyone to explain this terminology because it doesn't require any expertise. To say, well, it's going to demonstrate backlighting, it's backlighting on a movie theater screen that doesn't even have the same movie playing at the same time. So we're looking at this white effect on these photographs. What happens if it was darker? What happens if it was a mix? It's completely inaccurate because nobody can ever recreate the scene. So I understand that they're saying that the sheriff's office investigation wasn't great. I'm admitting it wasn't great. I mean, any reasonable person would view this case and say it wasn't great. But no one in the world can recreate it. It's just impossible. Like I said, let's say they put the movie on the screen. You can't then say, here's where Chad Oulson was, and here's the angles, and this. You can't recreate it. It's just not possible, no matter who you are. So there's just no way to accomplish this. It doesn't mislead the jury, and this terminology is not outside a juror's common experience that requires this type of evidence anyway. And the best evidence will always be the video and the eyewitnesses that were there.
Your Honor, it was a lot more than it wasn't great. As we know, in the law of self-defense, we have to have the trier of fact stand in the shoes of Mr. Reeves. I'm glad that Mr. Rosenwasser thinks that he's an expert on what jurors know and what jurors don't know with reference to the issue with reference to silhouetting, but we can't take that chance in a court of law. We never know what 6 members of a jury know and don't know. And I've been doing this for 37 years. I would never take that leap to just say, oh, well, they must. The trier of fact needs to stand in the shoes of Mr. Reeves, which means the trier of fact has to be thinking of themselves as 71 years of age at the time. The trier of fact needs to be seated in the same seat as Mr. Reeves. The trier of fact needs to be in the same darkness as Mr. Reeves experienced. The trier of fact needs to be in the same noise level that Mr. Reeves experienced. The trier of fact needs to be seeing the backlighting that Mr. Reeves was experiencing. The trier of fact needs to be in the same health condition as Mr. Reeves. The trier of fact needs to know the use of force and the danger cues that are taught to all police officers, and even more for Mr. Reeves. All of those factors, the jury has to stand in his shoes and make a determination whether his assessment that it was reasonable for him to fear death or serious bodily injury, whether that was reasonable. And so how can not, the problem here is that the crime scene detective did not do a great job by any stretch of the imagination, and the detective, the lead detective himself, admitted on this stand that he didn't have the tools himself to investigate a self-defense case. And so now Mr. Rosenwasser is saying, well, we didn't do it. We didn't capture it. We didn't do all these things that really should have been done in order to assess Mr. Reeves's perspective of what was going on. And so, but we don't want you to present it as a demonstrative evidence so that we can aid the jury somehow in making that determination. Mr. Knox is not going to be saying that what's on the view of the mannequins is exactly what Mr. Reeves experienced. The jury is going to determine all of this based upon all of the evidence that we're giving them. This is a demonstrative evidence just strictly on the issue of backlighting and an individual in similar size as Mr. Oulson standing in front of that seat 9.
All right. Thank you. I would have preferred to focus primarily on the argument. The issue that I've asked about is the accuracy. Is it accurate? And within the realm contemplated by the case law, do we have any more guidance on that? I can't get into Westlaw.
Judge, I think I read the Brown case. I thought that it is a very good. It's a flexible, yes, accurate, reasonably accurate.
Accurate and reasonable reproduction.
Exactly.
And there's 15 cases that cite this head note. I would love to see some of them if I could log into Westlaw, but I can't. So does anybody have any of those that more propound a little bit better description of what
We can
accurate and reasonable reproduction? So obviously Mr. Rosenwasser has pointed out some significant differences. I'm not quite as concerned about the backlighting and the exact moment because the pictures that I saw had a variation. There was a pretty good mix.
And we did that on purpose.
Light and dark. So, and obviously there's not any sound connected with this, right? And they're not moving, correct? So what are we talking about, the differences with the mannequins? How much different are they from the actual folks? and the perspective.
Your Honor, they're a human body mannequin, just like the head in the Brown case was a styrofoam head. You're not required to exact every description or every feature of a styrofoam head, just like you're not required to do that with in a human body mannequin. That's why I'm saying that I think that these distinctions, are not the type of distinctions that we can attribute to a 403 argument. They're just not the type of distinctions that we can put a level of prejudice on. And so that's been my argument all along. Again, if I was going to have, Dr. Knox come in here and say, this is what Mr. Reeves saw, I'd be with you. I'd be with Mr. Rosenwasser. I'd be saying, hey, listen, I can't do that. We're not going to do that with our other experts. And so this is purely demonstrative for one purpose and only one purpose alone, and that is showing what happens when you have an object in front of, for example, Mr. Reeves, and backlighting, and what that does to that process. And I'm not going to take the opinion that these jurors all have experienced that and know exactly what backlighting is when someone gets in front of them with a screen behind them emanating light.
If this is not to represent what Mr. Reeves saw, it's not relevant. I mean, really, that's it in a nutshell.
All right, well, to put my decision into context, obviously the state is asking me to exclude some testimony and evidence that the defense feels is very pertinent to their case. So clearly I need to get this right. And I'd like to have all the information.
Judge, if you give us 20 minutes, we can do this. I frankly thought this issue was done yesterday. Nobody called me yesterday to tell me, hey, listen, get prepared because I'm bringing this issue back up again. If not, we would have done it last night.
I did say it yesterday. We need to address the issue with Mr.
Yes,
Knox again before he testifies.
he did. As I indicated, I'm sure we've all done plenty of Williams rule cases where you can have, the same sort of thing. How similar is it? And you can list 15 different similarities and then, maybe a few dissimilarities. And the case law is clear that it doesn't have to be exact, and typically it isn't. So you get that discretion in there. And Brown simply says, did the exhibits constitute accurate and reasonable reproduction of the objects?
Right. If I could, I presented Brown to you, and you have to look at what the demonstration was for. You can't have a live human and place a knife in the skull to show the position so the jury can know the angles. That's what Brown was. So the styrofoam head served the purpose in order for the knife to be placed so visually they can see the angle which was relevant to how something happened. So did it fairly and accurately represent that? Yes. There's a human head that is approximate. We all have basically a nose, cheekbones there. It was there, and it was at an angle. That's what they said. It had to be fair and accurate. Here, we have none of that. It's not fair and accurate at all. And so that's how we distinguish Brown, is for what the purpose is. That was for the angle. This is what did the defendant see. And if you can't reproduce that, then it's not relevant. They were able to reproduce the angle of the knife in the skull accurately so the jury could have a visual representation. You can't do that here because of everything that Mr. Rosenwasser listed. And so it doesn't meet that standard.
Well, the argument in Brown was that, the defense argument was that there's no way to tell how deep the knife went in. There was no, that wasn't, that was an unknown.
But that wasn't the issue.
Well, it kind of was, whether he intended to kill her or not. And so they, wanted to know, it does make a big difference if it goes in deep or not. And so that's, like I said, just like with Williams' rule, you can point out as many as you want. There's this and there's this on both sides. And I'm just not convinced to the point that all of these disparities are enough. I'm just not. So I would like to, if there is any more guidance, particularly if there's something from the Supremes, that would be beautiful. About like just some analogies to what is reasonable reproduction.
Judge, if I could just have a suggestion, if maybe everybody can go to lunch early, and during lunch we will do it.
10:45 at lunch.
What, maybe just do another witness instead? And then
We don't have another witness instead.
Isn't Bedard here? And then just as the...
Bedard's going to be huge, and now then we're going to have a break in the middle of Bedard. We could get, I think, Knox. Knox is not going to be that long. My suggestion would be we take a break, we do the research, and come back and start.
All right, I'm gonna 10 minutes. I can go to my office and look this up on Westlaw in my office. I'll look at what we've got, and I'll give you my decision when I come back. That's what it boils down to. And I already indicated yesterday that I was going to deny the state's motion in limine regarding this, or I don't think that wasn't part of your Daubert, was it?
It was.
Okay, then
Because it has all to do with cameras and backlighting and whether it's
Okay,
accurate.
all right, that brings up the other issue. What about the camera? Where was the camera? How much difference is that?
The camera was positioned exactly where Mr. Reeves's eyes would have been, in his seat. There were measurements that were taken. I was there when that happened, and I can certainly speak to Mr. Knox and verify all that.
Mr. Rosenwalzer, you disagree with that?
I do. I have a copy of his deposition. And let me find the exact page and I'll show it to the court.
Because there comes a point when a lot of small inaccuracies can overcome a reasonable reproduction.
And I have it right here. Okay, this is page 101 of his deposition. Did you, and Mr. Martin, question, did you measure the height of the camera above the floor at the time you were taking the pictures? Answer, I don't recall if I measured the height of the camera. I set it at my eye level as I sat in the seat. So I sat in the seat pretty much straight up and set it to my eye level, but it was a tripod right in front of my eye. Did you take measurements of what your eye level was? No, I did not. And then then he talks about how the tripod was put on the floor in front of the seat where he was sitting, where he took the picture of his own eye level.
And how tall is Mr. Knox?
I don't know, Judge. I'd have to ask him.
And
Yeah, I can tell you he's not
also
as
you have
tall
to
as
take
my
into
client.
consideration where he was sitting. Was he leaning to the left, like Joanna Turner said? Was he leaning back in his seat? There's so many different variables about the height of his eyes. I mean, it's just impossible to recreate this. I mean, I can't think, like when you ask the question, which is, what else is accurate or inaccurate? There's nothing about this is accurate other than the fact these pictures are taken in a cop theater in a seat. That's the only thing that's accurate. Every other variable is inaccurate.
Reasonable reproduction.
there is no reasonableness in it because there's nothing remotely accurate other than the fact the pictures are taken in Theater 10, and they weren't even taken in the seat because the tripod's on the ground, so you can't even use that. The only thing that is reliable or reasonable or accurate is the pictures were taken in Theater 10.
The mannequins appear to be of human beings.
Okay? But human beings have 5,000 different variables. Probably my mannequin and we'll use Mr. Martin's mannequin look very different. So just saying a generic mannequin that looks like a human body doesn't mean anything because we're very different body styles.
Are they similar?
No, it's just a mannequin in a human form. And it really does matter. The broadness of the chest, the broadness of the shoulders, the head, the neck, all of that makes a person unique. This is just some generic mannequin, so it's not reasonable to have a generic mannequin, and it's not even reasonably accurate because all it is a mannequin.
Judge, again, whether you're 5'7", whether you're 6'1", it's the backlighting. That's the demonstrative issue here. It's the backlighting. He continues to try to gravitate, okay, to trying to tie this demonstrative aid as saying, this is exactly what Mr. Reeves saw. That's not coming in. We're trying to show the effect of the backlighting when someone, in this case it was a human body, but you could have a backlighting and have something even smaller than this just go in front of you and it's going to have some of that effect. So we're not trying to tell this jury that this is exactly what Mr. Reeves saw. It's to show the effects of backlighting when a human body comes in between the backlight and the individual that is viewing that. So if you're 5'7", it doesn't mean that the backlighting doesn't occur. If you're 6'2", it doesn't mean that the backlighting does occur. It's the body coming in front. He's trying to gravitate his argument to suggest this is what Mr. Reeves actually saw. I would agree with him. I would agree with him. Under those circumstances, you shouldn't allow it in. That's not what we're doing.
All right. Let me take 10 minutes.
Recess for 10 minutes. Johnson, I just shouted for the jurors in here for a moment and give them a little instruction.
Yes, please do.
Thank you, everyone. You may be seated.
I'll fetch my colleague, John.
Okay, thanks.
Finishing up slow printer.
Okay. All right, I did find a few cases of interest. Ultimately, I got to Chamberlain v. State, which is 881 Southern 2nd, 1087, Supreme Court of Florida case, which cites their previous ruling in another case. It was a recent ruling. Said in Chamberlain, the standard for allowing demonstrative evidence at trial was recently reiterated by this court in Harris v. State, 843 Southern 2nd, 856 at 863. That's a Florida decision, 2003, wherein we stated, demonstrative evidence is admissible only when it is relevant to the issues in the case. It is essential in every case where demonstrative evidence is offered that the object or thing offered for the jury to see be first shown to be the object in issue, and that it is in substantially the same condition as at the pertinent time, or that it is such a reasonably exact reproduction or replica of the object involved that when viewed by the jury, it causes them to see substantially the same object as the original. The person offering such evidence should be required to give a good reason for its acceptance into evidence, and this is particularly true if the object be not the original but only a replica or a facsimile. The determination as to whether to allow the use of a demonstrative exhibit is a matter within the trial court's discretion. So, Mr. Escobar, I believe
I've got an Supreme Court case from 2018 dealing with mannequins in and of itself.
all right, what is it?
It's called Lowe versus State, located at 259 Southern 3rd, 23. It's a 42-page opinion. However, I have outlined the areas that they deal with mannequins. I believe they start at head note number 5 through 11. I've only got half the opinions being printed right now.
So give me the site again, 259 3rd.
259 Southern 3rd, 23. So 2018 Supreme Court of Florida opinion. And it deals specifically with mannequins. I'm handing that to the court. And my other pages should be here momentarily.
Teresa's right outside. She says, do you want her?
Can you see something? Tell me what relevance.
Judge, I think that when you look at that particular case, they were actually using the mannequin for...
Wait a minute. Just tell me what the relevance is, please.
the relevance for our mannequins is the
Yes.
backlighting.
The backlighting is relevant to what issue in the case?
To what Mr. Reeves could have experienced, the backlighting, what Mr. Reeves would have experienced in the theater.
Okay.
Meaning not that exact mannequin,
Okay.
not that,
Okay.
but the
Okay,
backlighting.
that's all I asked.
Okay.
One more.
Yeah.
So how is that issue relevant to Mr. Reeves' defense?
It's relevant, Your Honor, because it actually blocks the light that was coming from the theater screen, which actually causes shadows in the individual that is causing the backlighting. That's the whole purpose of the backlighting issues, that phenomenon actually causes shadows when you're looking at it.
Okay. What issue are you trying to bring forth?
I'm trying to bring forth the issue that this was Mr. Reeves's perspective, the actual backlighting. He actually experienced that during the actual shooting. And so because we have to stand in his shoes in order to be able to make that assessment, we need to have that factor, just like all the other factors that he was experiencing that day. Backlighting was a factor that clearly, because Chad Oulson stood up.
Okay.
Okay.
All right, and in this Lowe case, has the state had the opportunity to review anything to do with the Lowe case?
I have, and if it's okay, because I'm reading it to argue from a seated position.
You may.
The mannequin was used by the medical examiner in order to demonstrate to the jury the trajectories of the bullets. And in the Lowe case, and I'm looking at head note 5 in the body of the opinion, it indicated, quote, the medical examiner then used the mannequin, which was slightly taller and thinner than Burnell and had valves inserted into it, to demonstrate the relative trajectories of 3 bullets that entered the victim's body. The medical examiner testified because he could not state what position Brunel was actually in when she was shot. He could only give anatomical, not spatial trajectories, and that the trajectories had a small degree of error. And the court, in overruling the objection, actually asked, what would be the difference if it was off a few degrees one way or another? Because the analysis was, as the court was indicating, is it reasonably accurate? Is it a reasonably accurate reproduction? And that was why, in the Lowe case, that mannequin was able to be used. In this case, Mr. Escobar just indicated exactly what our argument was. He wants to argue that this is the defendant's perspective. And there is no way that this camera, held by a tripod on the floor in front of Mr. Knox sitting in a seat, could possibly replicate the defendant's perspective. The only person that knows the defendant's perspective is the defendant himself. So that's exactly what we thought he was trying to admit it for, to say this was the defendant's perspective of the backlighting. It can't be any more misleading than that. Only the defendant. The defendant can have, it's his choice whether he wants to testify or not. I mean, Michael Knox can't say, based on a picture I took using my eyes, that this is what the defendant's perspective was.
No, he can't say that. But
That's what their argument was just now. This is being shown because you asked him what's the relevance, and his argument was the defendant's perspective of what the defendant saw regarding backlighting.
Your Honor, the issue is backlighting itself, not what is shown on those mannequin photos, because Mr. Knox can't say this is exactly what Mr. Reeves says, but the phenomena of backlighting is what's important to us. And something that's very interesting in the Lowe case. In the Lowe case, they used those mannequins for a far more intricate forensic analysis than what we're using it for. And by the way, our mannequins are 5'9", so they are going to err on the side of conservative, because if they were 6'6", okay, they'd be arguing, wait a minute, it's blocking, more light. Our doctor actually did it far more conservative at 5'9". That's the relative size of the mannequin. And so I would say that what we're using it for is strictly for the backlighting effect.
all right, a couple of things of note. In the Lowe case, it points out the fact that the mannequins were not specifically identifying or made to look like the individuals involved, so as to perhaps evoke an emotional response from the jury. So I didn't see any issue with that in these mannequins. And so obviously it would not, according to the Supreme Court, it would not be a good idea to use mannequins that are, more identically patterned after the individuals involved. Secondly, I lost my train of thought. The overall impact, the size, as you indicated, Mr. Escobar, I believe in Chamberlain, which I cited earlier, the state used a much larger version of the weapon.
Asp, it was an asp.
Yes, and the court found that that was okay. In this case, as you indicated, this is a smaller mannequin. I understand the distinction there. Obviously, if you used a much larger one, that would be subject to further scrutiny, but in this case, as you indicated, it's more conservative. This is within my discretion, and in considering all of the aspects, the case law, the reviewing the photos that were provided to me, I am going to overrule the state's objection to this demonstrative, and we'll get to it.
Your Honor, could we have just a limiting instructions? I don't know the best way to craft it, maybe something to the effect of, this testimony is being offered only to demonstrate the concept of backlighting.
Judge, I'm gonna go outside with the court's permission in a little while and instruct Mr. Knox, to stay within the parameters of his opinion, and that's only as to the fact that backlighting is created when an object comes in front of that backlight to create the shadow. That's going to be his testimony. He's not going to say anything beyond that. It was never intended to do anything else.
All right, so if there was a limiting instruction such as Mr. Rosenwasser indicated, I don't see any harm in that either as to that portion of his testimony. Say it again.
This testimony is being offered only to demonstrate the concept of backlighting.
All right, I think that's fair as to that portion of his testimony. So can we
I would agree with
pause?
that. And Judge, I would agree with that. I don't have any problem with that. That was our intent from the very beginning.
All right, so we can pause briefly before he begins that portion, which will include the PowerPoint.
I will make sure that that happens.
All right, all right.
Can I go and
let's-
talk to Mr. Knox now?
Yes,
And
please.
try to get that,
Before you go. Just one thing, the fact that they used a mannequin, I mean, it is kind of interesting to demonstrate the backlighting. So I've intended to ask him, and I don't know how you want to handle it. I don't want to open the door into, Pandora's box, so to speak, that, in this case, he chose to use mannequins. He could have used any object at all, but he chose a mannequin. I mean,
Judge, he chose a mannequin because of the fact that if he would have chosen a TV like this and it would have been, very, very dark, then we would have gotten objection. The reason is a mannequin is a human body. Human bodies have arms, they have areas of the neck that are a little bit.
Okay,
That's why
so
we used it.
Mr. Knox can certainly answer that without opening Pandora's box.
Okay.
Just that simply.
I will talk to him and make sure that he is.
Okay.
Give you an idea of what Mr. Knox said about why you use a mannequin and not a board or something, if that's what the court wants.
I don't care.
Okay.
If Mr. Rosenwasser wants to bring that out on cross, I'm sure we'll hear. It's not that I don't care, it's just, at this moment, I don't care. It's okay, and that's up to Mr. Rosenwasser when he does his cross, but as I indicated, that's not going to open the door for every other thing to come in.
Yes, Your Honor.
It'll be answered accordingly, and we'll go from there. All right, let's bring the jury back in, please.